In 2013 and again in 2014, a company in Tempe, Arizona took in more than $200 million a year. That figure comes from the Federal Trade Commission's complaint. So does this one. Citing the company's own income disclosure, the FTC's complaint states that more than 93% of the people selling its product earned less than $6,169 in a year. More than 40% earned less than $939. The product was an energy drink called Vemma, and the people at the bottom of it were, in large numbers, teenagers and college students who had been told that this was the thing that would let them skip the degree, skip the debt, and drive a new BMW inside 90 days. In 2015, the FTC went to court to shut it down, alleging it was a pyramid scheme. More than 14 months earlier, a federal appeals court had already handed the agency the exact legal tool it needed. And when it was over, the people who lost money would get back an average of $78.93 each. This is the anatomy of a scam. Vemma Nutrition Company operated out of Tempe, Arizona, run by a man named Benson Barreco. It sold a nutritional energy drink through independent distributors, who the company called affiliates. That structure is not illegal. Multi-level marketing is a lawful business model. Thousands of companies use it. What determines whether it is lawful is a question that sounds technical and turns out to be everything. Where does the money come from? If the money comes from selling a product to people outside the network, real customers who want the thing, it is a business. If the money comes from recruiting new participants who pay to join, it is something else. The law has a word for that something else. The FTC alleged Vemma was the second kind. And the way the agency told it, the target was specific. The complaint describes a marketing campaign called YPR, the Young People Revolution, sometimes the Young Professional Revolution, and states that it, quote, targets young adults, including college students. The FTC alleged the materials, quote, prominently feature young, seemingly affluent individuals surrounded by conspicuous displays of wealth, such as luxury vehicles, jets, and yachts. And the complaint alleges something more direct than imagery. It states that the defendants, quote, visit college campuses and present Vemma as a profitable alternative to traditional employment. Not a side hustle, an alternative to the thing those students were, at that moment, taking on debt to obtain. The pitch, as quoted in the FTC's filing, was not subtle. Barreco is quoted saying, we have a game plan to get you earning $500, $5,000, or even $50,000 per month. And I'd like to lay out a game plan that can give you the opportunity to get profitable fast and be driving a new BMW within the next 90 days. The complaint quotes affiliate testimonials aimed squarely at the young. How does it feel to be 19 years old, making $5,000 a month promoting a healthy energy drink? And another, recorded in fragments, describing a 17-year-old who reached a top rank in 21 days. Remember that these are quotations from a regulator's complaint. They are what the FTC said the company was telling people. That distinction matters, and it will matter more in a few minutes. Here's how the FTC alleged the money actually moved. Step 1. You buy in. A new affiliate purchased what the company called an affiliate pack. The complaint puts the price at approximately $500 to $600. Before you have earned anything, you have paid roughly the cost of a month's rent for the privilege of participating. Step 2. You keep buying. To stay eligible for bonuses, the complaint alleges an affiliate needed to purchase approximately $150 of product every month on automatic delivery. That is the detail that separates a job from an arrangement. An employer does not charge you a monthly fee to remain employed. Step 3. You recruit, and this is where the FTC's central allegation sits. The agency alleged the bonus structure rewarded bringing in new affiliates rather than selling the drink to people outside the network. Now, a careful distinction. In September 2015, a federal judge in Arizona ruled on the FTC's request for a preliminary injunction. At that preliminary stage, the court said the evidence showed that, quote, the bonuses affiliates earn are primarily for recruitment of other affiliates, not the sale of products. The same order said affiliates were, quote, very likely engaging in inventory loading, buying product because you need to qualify, not because anyone wants to drink it. The product moves. It just moves into garages. Be precise about what that ruling was, because this is the part most retellings get wrong. It was a preliminary finding, at an early stage, on whether the FTC was likely to win if the case went all the way. And then, in December 2016, it ended without a verdict. It ended with a settlement. The stipulated final order was entered on the 21st of December, 2016. Here is what it did. It permanently banned the defendants from any business venture that pays compensation for recruiting new participants, that ties a participant's compensation to that participant's own purchases, or that pays compensation unless the majority of revenue in that period comes from sales to people who are not participants. Read that last clause again. It is the entire business model, prohibited by name. It imposed a judgment of $238 million against Vemma and Borrego. And then it suspended almost all of it. The suspension was based on the defendant's sworn financial condition, which is standard practice and is conditioned on those statements being truthful. The amount actually paid was $470,136. A separate order addressed Tom Alcazin with a judgment of $6,790,915, suspended on payment of $1,250,000. His wife, Bethany Alcazin, was named a relief defendant, jointly and severally liable. And in the findings section of the Vemma and Borrego order, at paragraph 3, sits the sentence that defines this entire episode. Quote, defendants neither admit nor deny any of the allegations in the complaint, except as specifically stated in this order. Neither admit nor deny. There was no trial. There was no jury. There is no final judicial finding that Vemma was a pyramid scheme. The company signed away the business model and conceded nothing. Then in September 2019, the FTC returned money to what the agency called affiliates who lost money. More than $2.2 million, distributed among 28,224 affiliates. The FTC put the average at $78.93 per person. $78.93 against a $600 buy-in and $150 a month. Vemma's judgment, $238 million. Vemma paid $470,136. To be exact about it, Vemma admitted nothing. No court ever made a final finding against the company, and the case ended by agreement. What follows is not in dispute. On the 2nd of June 2014, the Ninth Circuit Court of Appeals ruled against a company called BurnLounge. That ruling established, in the federal circuit that covers Arizona, how to identify a compensation structure that pays for recruitment rather than sales. $16.2 million in redress. The legal standard was settled. The precedent was on the shelf. The FTC filed against Vemma in August 2015. More than 14 months later. In the interval, according to the FTC's complaint, Vemma took in more than $200 million in each of 2 consecutive years, and the campus recruiting the complaint describes continued. The tools existed. The doctrine existed. The delay is documented, and it is measured in months during which young people were signing up. Then there is the question of who was watching from inside. At the preliminary injunction stage, The court said Vemma contacted only 15 of its more than 90,000 affiliates in a month regarding compliance. 15 out of more than 90,000. That is roughly 1/6,000th of the network per month. Our arithmetic, not the court's. Whatever that system was designed to do, catching what recruiters were telling 19-year-olds on campuses was not a function it could physically perform. And the campuses. The FTC's complaint says recruiting was conducted on college grounds, aimed at enrolled students, with a pitch positioning the degree they were paying for as the inferior option. The public record before us shows no institution intervening. That is not proof that none did, but it is a silence worth naming. Someone always knew. This is the part that matters if you are ever on the receiving end of a pitch like this one. Everything in this list comes from what the FTC alleged, or from what the court said at the preliminary stage. Take them as a pattern to recognize, not as a finding against anyone. Here is what a careful observer could have seen. 1. You had to pay to start. A $500 to $600 entry pack is a purchase, not a job offer. Legitimate employment does not have a cover charge. 2. You had to keep paying to stay. Roughly $150 a month to remain eligible for your own commissions. Ask yourself who that requirement is designed to benefit. 3. Ask who the outside customers are. The single most useful question you can put to any opportunity like this. What percentage of revenue comes from people who are not participants? If the answer is vague, or if the answer is that the participants are the customers, you have your answer. 4. The income disclosure was published, and the numbers were stark. 93% under $6,169 per the FTC's complaint. When a company publishes an income disclosure, read it. It is the one document in the entire pitch that is not trying to sell you anything. 5. The lifestyle was the product. Jets, yachts, a BMW in 90 days. When marketing shows you the reward and never the work, the reward is the bait. 6. It targeted people with no baseline. 17, 19, 26 years old. An audience with no reference point for what a normal return on work looks like is an audience that cannot spot an abnormal promise. 7. It positioned itself against education and steady work. Any pitch that frames a degree or a regular job as a thing holding you back is selling urgency, not opportunity. 8. The compliance function could not physically function. The court said at the preliminary stage that Vemma contacted 15 affiliates a month out of more than 90,000. If you had asked who polices what recruiters promise, the honest answer was almost no one. Vemma admitted nothing. The judgment was $238 million, suspended on sworn inability to pay. The amount paid was $470,136. The affiliates the FTC identified as having lost money got $78.93 each. And in May of this year, 2026, the Federal Trade Commission settled with the lead defendants behind a trading education company called IM Mastery Academy, a company the FTC alleged ran a deceptive multi-level marketing operation that generated more than $1.2 billion since 2018, and whose operators, in the agency's words, focused their deceptive marketing on young people and used social media posts flaunting luxurious and expensive lifestyles. That case, too, settled. Those defendants, too, have not been found liable at trial. The FTC's allegations describe the same playbook, aimed at the same age group 11 years later. You've been watching Anatomy of a Scam. Someone always knew.